is State of Ohio versus Stephen Gilbert. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve rebuttal time, please let me know, as I'll be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, or victims during your arguments. You can refer to them by initials or terms like the child. We've read your briefs and we're prepared to proceed when you are.
Thank you, and may it please the court, Kimberly Kendall Crawl on behalf of Stephen Gilbert. I would like to reserve 5 minutes for rebuttal. Will the court let me know when I use my pen, or should I monitor that myself?
I'll give you a warning if you start going into your rebuttal time.
Okay, thank you so much. As a preliminary matter, the court has the briefs and knows the issues that are before it. I think the most compelling issue in this case are sort of an overlap of the way competency, the interest in self-representation, and the interest in terminating counsel overlapped each other. This client raised competency issues for a period of years leading into his trial. He drafted a letter which was addressed on the record in the pre-trial, which I would concede on its face may be evidence of malingering of competency issues, that maybe he's faking competency, but the consistency with which competency was discussed and indicated gave rise to a requirement for the court to ensure this person's competency prior to engaging in trial, and no competency hearing was ever held. It is the court's responsibility, and we raised it as court error because the court has a responsibility to ensure that one is competent prior to standing trial.
And you're saying this was raised multiple times in this particular case?
In this particular case, he had addressed the court, letting them know that he believed he had competency issues. It was addressed. The court called over to the jail, who said they don't think he has competency issues. But the fact that the court took the time to call to the jail, there's not someone at the jail, like a CO at the jail isn't the appropriate person to make that determination.
So my understanding is he had 4 or 5 different lawyers. Did any of those lawyers put in writing that competency could be an issue, like a motion for a competency evaluation?
Well, here's some of the issue, and I think this issue is specific to the 9th, and I know in the 9th district, and I know in prior appeals I've had, the 9th seems hesitant or unwilling to address errors that are raised as ineffective assistance of counsel if they weren't first raised by counsel. Now, it's my opinion that because ineffective assistance of counsel is a constitutional claim, it should be considered, even if it wasn't, if the ineffectiveness raised to the level of denying effective representation, it should be considered. But the 9th has quite a lot of precedent which says if it wasn't raised by counsel, it's only plain error. In this case, I don't think it should be a plain error standard because the court has it's the court's duty to ensure competency, not counsel's.
Don't you have to have an indicia that the person is incompetent, that they don't understand the proceedings? If the judge is satisfied with all of these proceedings over the years, that it seems that the defendant understands the proceedings, he's not required to then order a competency eval.
He is required to order a competency evaluation if he has questions about competency.
But that's what I'm saying. Does it appear on the record that he had questions about competence?
Yes, because he says he called the court to determine, or he called the jail to determine whether there are competency issues, but no one in jail is qualified to make that determination. It has to be the court clinic.
But the judge also had the opportunity to observe him over many proceedings as well, right?
Well, if the standard is whatever the judge thinks, but that's not the standard. The standard is if there's indicia on the record that there's a competency issue, which there is, then
What was that?
that he raised several times that he thinks there's something wrong with his mental health, that he has competency issues. The jail confiscated a letter where he talked about raising competency issues. Just firing 4 or 5 lawyers, one of the standards of competency, there's 2, subsection, there's 2 parts. 1 is the ability to understand, but 2 is the ability to work with counsel. So the fact that he had 4 or 5 lawyers, and I don't remember from the record if it was 4 or 5, but I can look, but the fact that he had so many lawyers is in itself indicia indicia that he is not meeting the standard, because the standard is two-part, and that second part is really important.
Isn't this a unique case though, where we also have evidence on the record that he was planning to feign mental health issues?
And I think I began by saying, we can concede that I think he wrote a letter that indicated some malingering or feigning, but malingering is still a standard which has to be evaluated by someone competent to make that evaluation, which would be the court clinic. Certainly, the court clinic could say, he is showing some competency issues, but he appears to be malingering. That's a diagnosis that no one in the jail is able to make, and that one letter, I mean, frankly, the fact that he would write that in a letter indicates in itself some competency issues.
Well,
Isn't,
usually a defendant in front of us doesn't bring up his own competency, because the whole point is they're not competent really to do it.
but he did bring it up.
I know, and that's what I'm saying, it's unusual, isn't it?
It is unusual, but I think anytime there's an indicia of a competency issue, the case law says the court is required to ensure his competency, and the mechanism for doing that is ordering a competency evaluation, and none
Well,
was
there's
done
not
in
a
this case.
mandatory duty to order competency evaluation.
No, it's not mandatory in all cases. There is a mandatory duty to ensure competency.
Right.
Before
what I was saying.
proceeding.
The court in interactions with the defendant might have been able to ensure the competency of the defendant himself.
But the record is void of that. The record indicates that he called the jail and someone in the jail insured him, but that is not the appropriate person. I mean, there is case law which requires when the record has an indicia that a competency evaluation, it doesn't use the term mandatory, but that we shall determine competency via the prescribed procedure, which is a competency evaluation. It wasn't done here. Then he tried to fire counsel. He was not permitted to fire counsel, and he was sort of derailed from his efforts to represent himself, where competency again was a part of the record conversation on that. And so the way that these things are overlapping, I think so often in case law we focus on whether the person understands the procedure, but the law requires both understanding the procedure and the ability to work with counsel, and he did not demonstrate that throughout. One of the other issues we raised was his insistence on wearing his jail clothes. Now, that, again, demonstrates incompetency. He's not acting in his best interest. He clearly doesn't understand the effect of wearing their jail clothes in front of a jury. The court, I believe, erred in refusing to instruct that they can't consider his jail clothes. I think the court's in a position it draws more attention to it.
Didn't the court though determine that all those things seem to be manipulative? For example, when you get a new lawyer multiple times, you delay the trial. And when you don't assert your competency, start saying you're hearing voices right before your next trial and assert competency, but then there's some evidence that he's gonna fake that from the officer. He's again trying to, he's competent enough to try to manipulate the system. Don't we have evidence that that's what's going on here?
I don't think this court can take evidence.
Well, he did take evidence.
I don't think this court can, de novo decide whether this person was competent or not, because this court hasn't observed him. You have to look to the record, and the trial court, the lower court, did not establish in the record that this person was competent. There are numerous.
We're gonna have a record where the court had multiple court proceedings with this person, and we'll be able, the court can, from the proceedings, we could see if he seemed to understand the proceedings, which is a standard, and able to work with counsel. And we would have to, wouldn't we have to know, the judge would have to make a judgment call of whether the working with the attorneys is something that would raise a competency problem, or if it's another issue.
How would the court make that call? What training does the court have in competency to make that call?
Well, I think maybe you're confusing competency with mental health. I mean, just because the person has a mental health issue, doesn't mean the judge couldn't just, as a lay person, say you're understanding the proceedings.
This court is bound by the record, and the court is silent onto his opinion of the defendant's competency. If the court said, I find you to be competent, I'm not gonna order a competency evaluation, then I think you would be right. But the court doesn't say that. The court addresses all these competency issues with no resolution. And maybe what I feel like you're suggesting is we can extrapolate from the fact that he didn't have a competency evaluation done, that he maybe thought he was competent, but that is not the standard. He didn't meet the standard, and the record has to be clear that he is competent. The way the record is made clear that he's competent is a competency evaluation, which establishes his competency, and that is not a part of the
So
record.
you're saying as part of the duty, the judge should have, without a competency motion being made by anybody, other than the defendant mentioning a couple times that he felt that he was not competent, but he didn't have it mentioned by the attorneys, no formal motion, that the court should have evaluated at least the necessity of ordering sua sponte on its own a competency evaluation.
Yes, and I don't think it's just me saying that. I think that is the legal standard and the case precedent. And
Excuse me.
no, that's okay. If you need a break or anything,
No,
obviously.
I'm just making a lot of noise.
That's fine. If, as soon as the record gives rise to issues of competency, and in this case, to me, what gives the most rise is the fact that the court put on the record, I called the jail.
You're in your rebuttal time, I'm sorry.
Okay, thank you. I'll reserve my rebuttal time.
May it please the court. Lindsay Poprocki of the Lorain County Prosecutor's Office on behalf of the state. I'd like to take a step back and look at who Stephen Gilbert was prior to his 2021 arrest. Stephen Gilbert was a pimp who ran a human trafficking and prostitution ring. Gilbert used the Skip James website to advertise dates with the women he trafficked out of motel rooms. These dates, or licks, were with Johns who paid for sex. The women gave Gilbert all the money they collected in exchange for drugs, and at times had to sexually pleasure him as well. Several victims testified that they were sexually and or physically assaulted by Gilbert if they did not listen to him, and that he manipulated and controlled them with the drugs that he supplied. Just as he manipulated and controlled the women that he trafficked, Gilbert attempted to manipulate and dictate the terms of the trial proceedings below in his favor. Several of his assigned errors focus on the trial court's denial of those efforts. Prior to the start of the trial, Gilbert not only tried to have new counsel appointed, but he also sought to represent himself and raise issues of competency, all in an attempt to delay his eventual trial, despite receiving and rejecting an offer from the state which he himself acknowledged to be a great deal. Gilbert did not always agree with his appointed trial counsel's defense and approach in this case, and his trial counsel was his fifth court-appointed attorney, but the existence of hostility and tension or personal disagreements that do not interfere with the preparation or presentation of a defense do not rise to sufficient justification to discharge a court-appointed attorney.
Counsel, if you don't mind, since we have such limited time, could you address the fact that, whether the record does reflect this or whatever, but address the fact that the trial court evidently called the jail?
And I would address that. And the trial court called the jail when Gilbert raised an issue of his competency in his drug case, an unrelated case to the human trafficking case in 2022. And he called the jail because Gilbert raised a competency issue at that time, and he confirmed that no issues of competency had been raised with the jail staff, and he determined that at that point, that was a delay tactic to proceed on that trial, which had also been set for that date. He determined that, again, that Gilbert was just trying to delay his trial in that case. And when competency issues were later raised, it was not until the April, I believe, 3rd or sometime right before the trial date was set in the human trafficking case. And there was testimony before the trial court that Gilbert had been heard by a deputy saying that he wanted to raise his competency and tell the court that he was hearing voices only again as a way to delay the trial and manipulate the court proceedings. So I
Do you
think,
believe the trial court has an affirmative duty in a case if the defendant is obviously or showing signs of incompetency to have a competency evaluation done without a motion by defendant?
does the court have an affirmative duty?
Right.
I-
As the appellant alleged, seemed to allege here, if he'd acted incompetently, the court has a duty to make that referral and have an evaluation done without a motion.
I do not believe that the court has an affirmative duty without a motion. I understand that there's an argument that the court has to sua sponte, have a competency hearing but a defendant is presumed competent. And given that the record contains no indication that Gilbert was unable to appreciate or understand the nature of the proceedings before him, the fact that he was uncooperative with defense counsel was not an indicator that he lacked competence to stand trial. And all the evidence before the court indicated that he feigned his mental health issues on the eve of trial to manipulate and delay the proceedings.
Well, I'm just trying to figure out, and I haven't read the record yet, we will. I'm just trying to figure out how all this extraneous stuff is coming into the court. I mean, officers saying this, judges calling jails, all that stuff is really not supposed to be happening.
So the issue of competency was raised at a prior plea in, I believe, June of 2022. So that has nothing to do with this case that's before the
But
court.
it's the same judge, right?
It was the same judge.
So in his mind, he already addressed the issue.
He had not addressed
Well,
the
he
issue
addressed
as
the issue
is
because the jail told him he was competent.
at that time.
So I'm making sure I understand what we're saying here, because you're saying it's a different case. So this record that's quoted to us in this case where the judge says, hey, I called the jail and they told me X, Y, and Z. Were those proceedings in the case before us right now on appeal?
That record is before the court.
Okay.
Correct. That proceeding with the drug plea is in this record. That's correct.
And is that an appropriate way for a court to determine competence? Say, hey, let me call the jail and see what they have to say.
That's not a competency hearing, no.
But the judge has to have an indicia that the person is
Correct.
competent. And if one factor could be that other people have observed him and they haven't seen any indicia either.
Correct.
I don't, is it in the record that he only relied on the jail phone call and that was it? I mean.
No.
Right.
The record indicates that he relied on deputy testimony, and the record relies on the fact that Gilbert said he had been hearing voices since he can't remember how long, but he had not raised the issue to the judge before. Well, he had not raised the issue again since the July 2022 incident until right at the eve before his human trafficking trial. And he had not raised the issue to his attorney until he indicated that he had not raised the issue to his attorney before a week before trial.
So the judge has taken this evidence at a competency hearing. What was specifically, is this just a pre-trial? How does this come up? The judge is taking the evidence about.
This second time at an April 3rd hearing, or right before the trial that went forward on his human trafficking trial, literally a week before.
And this was in response to defendant's comment that he may not be competent and not a motion
It
from
was,
his
it
attorney.
was in response to him wanting to proceed pro se.
Okay. And this was all in context of his request to proceed pro se.
Correct. This was in context to him wanting to proceed pro se, and then again, this was in the state's opinion and the state's view of manipulation and a delay tactic in response to him stating that he wanted to proceed pro se after he'd been denied the opportunity to discharge his court-appointed attorney, his 5th court-appointed attorney, and then proceed pro se, which was not a legitimate, unequivocal request, all in efforts to delay the trial court proceedings, in which he was found guilty by an overwhelming amount of evidence, sufficiency of which she does
Why do
not
you say that
challenge.
request isn't unequivocal? What was the conversation there that made it unequivocal? Because he's mentioned he might wanna represent himself, but he didn't actually ask. It's unusual when a defendant asks to represent himself that he's not allowed to do that. So, you're saying it wasn't a true request?
Again, the state does not believe it was a true request because he, again, said that he was only asking to represent himself to create an issue for appeal.
And again, we'll look at the record, but did the trial court make a written decision on this
Yes.
request? Okay.
Yes, it did.
And what was not the state's belief, what was the trial court's written decision as to why they did not grant the motion?
It was manipulative and it was made for purposes of delay. And I believe there's Ohio Supreme Court precedent in Casano and Dean that a trial court is permitted to deny a request simply for purposes, when a request is made for purposes of delay. That alone will allow a trial court to deny a request to proceed pro se.
Which motion are you talking about there? Are you talking
sorry?
about which motion are you talking about there? Are you talking about the pro se motion or the competency motion?
Pro se.
Okay, so the court did not specifically rule on the competency issue.
That entry, if the court does take a look at that entry, it does talk about the overlapping issue of competency and the request to proceed pro se. And as I believe defense counsel has indicated, these issues sort of overlap because they were addressed at that April 3rd pretrial hearing. The issues indeed overlap. We believe that they were all on the record and demonstrated that this was manipulative and delay tactics as exercised by
And
Mr.
did the
Gilbert.
trial court in discussing competency indicate that they did not see, trial court not see any indicia of competency, of incompetency at the time? In that order?
Yes, it did, because it indicated that he understood the nature of the proceedings before him. He went through the seriousness of the charges with Mr. Gilbert. He expressed that he understood the nature and seriousness of the charges with him. He indicated that he understood he was facing a sentence that exceeded his life expectancy, and that despite understanding that sentence, and receiving an offer from the state that he believed was a great deal, he rejected that offer. So he continuously raised issues about the way he thought he should be defended by his trial counsel. He understood the nature of the proceedings before him. This was a delay tactic. And also, as to his election to proceed in jail clothes, the trial court went through a colloquy with him, and again, he indicated that that was made. He was fully aware that he had the option to proceed in civilian clothing, but he made it for strategic reasons and chose to proceed through the trial in jail clothing. We would indicate that these assignments of error should be rejected by this court, and that Stephen Gilbert's convictions and sentence be affirmed. Thank you.
We have about 4.5 minutes for rebuttal.
Thank you. So this court has found itself, I think, after listening to the state, I have some clarity about the problem here. If he's competent, then the court committed structural and necessary reversible error in not letting him represent himself. His request was unequivocal. It was made not just the day before trial, on January 6th, on April 7th, and on April 10th of 2023. And those are transcript 194, 248, and 268. He set forth his view of the case, and his counsel specifically said this is not for the delay. My client isn't looking to delay, he just wants to make sure he's adequately prepared. So there was nothing before the court that it was about delay, but if he's competent, then he had to have been afforded the ability to represent himself under very firmly established United States Supreme Court precedent. And if he's not competent, then it's also reversible. But the competency law requires, under 2945.37, it requires that in a criminal action, the court of common pleas, county court, municipal court, prosecutor, or defense may raise the issue of defendant's competency. And when the issue is raised, the law requires, the court shall conduct the hearing required or authorized under Division B of this section within 30 days after the issue is raised, unless the defendant has been referred for evaluation, in which case the court shall conduct the hearing within 10 days of the filing of the report of the evaluation. And I don't want to spend my whole 4 minutes reading the statute, because it's clear that from the record, this was also not a last minute issue. On June 13th, 2022, nearly a year before trial, he first requested a mental health evaluation by and through his attorney, and that's in page 101 of the transcript. He then spoke directly to the court saying, "I feel I'm not competent to stand trial." That triggered the court's requirement, and under Ohio law, which embodies United States Supreme Court precedent, the court had to have a competency issue. It did not, and so it's reversible. The court indicated at that point, transcript 108, just for the record, I'm looking at the docket of the case back in 17. There was no mention of any competency issues just a few years ago. I called over to the jail and spoke with Margaret Boyce, head of the medical department, and he's not on any watch for mental health issues. And again, mental health issue is different than competency. And it's their policy that if anybody in their staff think there's a competency issue, they contact the court directly. And again, on April 4th, he stated to trial counsel in front of the judge in open court, "I asked you for a mental health evaluation and you never got me one." On April 10th, the letter comes up, and that's when the state puts a deputy on to get some evidence of the letter, but that does not meet the standard of a mental health competency hearing. It is not, there was no mental health evaluation, and if this court finds, which I don't think the precedent allows the reviewing court to come to a conclusion that the court must have thought he was competent. If the trial court didn't make a record that he was competent, I don't think this court can say, in light of the claims of incompetency, that he must have been competent or he wouldn't go forward, because in that case there would be no case where a case is overturned for competency issues. But if this court were to look and say, well, we believe what the state believes, which was that this was all manipulation, and he is competent, then he should have been able to represent himself. It was an equivocal.
Well, not necessarily under state 15, if it's manipulative or purpose of delay, he does not get to represent himself. That right is not unlimited. The court may decide, if the court believes the request is made for purpose of delay or manipulation of the trial process, the court may deny that motion.
Well, how do you say it's made for the purpose of delay when it was first made? I'm looking at the dates exactly. January 6th of 2022 and 2023, and trial wasn't until April of 2023.
Wade already had several attorneys though.
He had asked to represent himself.
I understand, but Judge Stevenson's asking you about delay tactics, and if there's evidence that it was for delay.
And now I understand from the state, that's what the trial court found, this is being done for delay and manipulation of the process rather than a legitimate.
That's because the state court elected not to rule on it until the week before trial, but the request was made January 6th of 2023, which is not made for the purpose of delay. But either way, if he's competent, if he's not competent to represent himself, which apparently is a part of the opinion, that it would be really bad, and that they, in the hearing on whether he should represent himself, they had them read a letter about his competency. And so if his competency plays a role in the decision of whether or not he should represent himself, i.e. he may not be competent to, then a competency hearing was required, whether sua sponte, but the court shall hold the hearing when it's raised literally by anyone, and it was raised by the defendant.
You're over time, so if you could wrap up in the next 15 seconds.
No, thank you, I think I made all my points before the court. I will say the court highlighted what its perception of what a bad guy Mr. Gilbert is, or the state, and spent a lot of time on that, but I think the Constitution equally protects Mr. Gilbert, and he's entitled to that same constitutional consideration.
Thank you both for your presentations. The court will take this matter under advisement and issue a ruling in due course. Also, the clerk of courts will mail you a copy of the decision on the day it's released. Additionally, the decisions are posted on the Ohio Supreme Court website. Thank you.